I will now call case number 118310 in Ray Holmes.
Mr. Chief Justice, and may it please the court. My name is Curtis Holmes. I am here on the court's request to enter argument on behalf of a petition for reinstatement. We're involved in a proceeding that started over 4 years ago. And we're finally here, hopefully, to resolve something that I think has been in need of some resolution for some time. The relevant court rule in this matter controlling the reinstatement is Rule 232. I have had an opportunity to review that. And I think that I have been able to present at the panel hearing in this matter sufficient evidence to show that I have complied for the most part with Rule 232. I've complied fully with Rule 231 requiring notice. I have required with most of the elements of Rule 232. I would simply indicate that I have been able to use this 4 years as a significant learning process. And to be very honest with you, even though I would request that my license be reinstated, as a practical matter, I will never be returning to the full-time practice of law. I'm currently employed very lucratively as a senior operations administrator with the Federal Express. Oddly enough, the skills associated with that position are tailor-made for an attorney. I am at a desk, I use a computer, I am using legal applications that I never was even aware of as an attorney. My job within the corporate sphere is correcting mistakes made by any number of individuals, most of whom are in the corporation itself, in order to serve the benefit of my customers. And that's something that has, I think, to a large extent, reintroduced something that I believe that I had understood significantly at the time that I entered the legal profession.
When did you make the determination that you're not going to enter the practice of law? Because part of the concern of the hearing panel was that you made representations. Hey, my suspension is going to be up pretty soon. I'll be returning and I might be able to help you. But that was some of the conclusion. So when did you make that determination?
Two significant things have changed.
Okay.
One is, at the time that I was doing that, I was working on a part-time basis in a completely different job than I am doing now. For the last 2 years, I have moved into the administrative field. Number one, it's much closer to the law practice that I had had than simply working as a package handler, which is what everybody is required to do when they start working for Federal Express. So I have essentially gone from this point to this point in the corporate sphere. Secondly, I am financially remunerated about as well as I was as an attorney. In fact, to an extent better than many years. I have no reason to return to a full-time legal profession, given the fact that I am in a new job that pays very well, that I am very happy with. And as a third thing, and I want to make this very clear, and it's nothing negative about the profession of law, but it's something that frankly was noticed by my wife. And that is, when I go to work, even though my hours are very odd because I typically go in about 1 o'clock in the morning, I don't come home with my work. My work is completed. I'm done. And she has told me on a number of occasions, Boy, you're sure a lot happier than when you were working full-time as an attorney. That being said, there are things that I would still like to accomplish.
So can I ask, and I'm interrupting and I'm sorry, but
No,
I
fine.
want to get right to what I take to be the substantive question here. Which are the 3 informal admonitions that you received while you were on your period of suspension?
Go ahead.
And would you agree that those 3 were the 3 main things at issue
As far as,
in the reinstatement hearing?
I don't know that those, I don't know that I would agree with that. I think that they did come up. I would also argue that they were directly related to the underlying suspension.
So let me ask you about those 3. And I'll just want to recite the facts real quick. So I know we agree on those. The first was this witness who hadn't been paid, who filed a complaint, but then quickly got paid.
Right.
And then you accepted an informal admonition.
Right.
And then there was the file that you were unable to return based on a change of address. And there was another complaint filed, but then when the address was found, the file was returned and you accepted an informal admonition. Is that
Right.
correct?
In fact, it wasn't the file. It was actually the balance of a retainer.
Oh, it was
there
money.
So there was some money.
Okay.
And I had sent a check to the only address I had for this person, and it.
But otherwise, I have the
returned.
facts, right? Like as soon as.
Oh, yeah, as soon as I found out where she
it was
was, it was automatic, it was immediately.
And then the third one, the third informal admonition came when it was alleged that you were practicing, you had unauthorized practice of law by the conversation Justice Rosen mentioned, where you told the spouse of a former client, hey, I'm suspended, but when I come back, which I think might be within this year period or whatever, I might be able to help you. Is that correct?
That essentially.
Okay, so
right.
And you heard me emphasize practicality, I think earlier this morning. Practically speaking, why did you acquiesce in each of these informal admonitions?
Because I believe that there was some underlying cause. I didn't believe that it was particularly egregious, but I believe that there was some negligence on my part.
Did you think there were rule violations? And I know I'm asking you a hard question because now you don't want to contradict yourself, but.
I believe that they're certainly in a gray area. I think that you could make an argument either way. And to be very honest with you, I acquiesced to those to a large extent to provide or to avoid
A prolonged
going
process of
through,
litigation.
yeah, a long, prolonged,
Is it fair to,
psychologically traumatizing ordeal,
it was easier not to fight it?
basically speaking.
And did you have any notion when you decided not to fight these, that they would be used to deny a petition for reinstatement?
I knew that they would come in as a factor. And I believe that it was certainly a possibility. But I'd been through a couple of informal admonitions previously, and I had not seen any impact from those previously. In any event, there is one area that I freely admit I need to catch up on, and I think I've done pretty much everything else, and that is that there are continuing legal education credits that I need to take care of. Unfortunately, I have had some work issues. I mean, simply volume of work that has interfered with that. I've also had some health issues that have impaired that.
If we grant your petition for reinstatement, when do you think it would be reasonable to think that you would be caught up on your hours?
I believe that we're coming up on the worst time of my work during the year, which is the holidays. As we get towards the holidays, my hours go from close to 50 hours a week, and then they suddenly jump to over 60 hours a week. That particular time would be very difficult for me to do it. However, there is traditionally a tremendous drop in the work schedule once the holidays are over. I would anticipate over a period of 2 to 3 months following January 1st, I would be able to take up the time to get the rest of those done. And as a practical matter, I want the court to be aware, I enjoy them. I've taught continuing legal education courses on a number of occasions. I taught in areas of both bankruptcy and on civil rights. And I have always enjoyed the continuing legal education courses. It's simply, I need to have the time available to sit down and take them. I would prefer to actually take them in a setting with fellow attorneys. But I would believe that within 90 days after the first of the year, I would be able to have those come. But I be very honest with you, I know what my schedule's like up until then, and it would be difficult. Only thing I would add is that, and I think that I stated it in the hearing or the panel hearing in this matter, and that is that again, this has been a tremendous learning experience. There's a natural inclination in me to do what is fair. And what I did that got me in trouble was following that inclination in violation of the rules. I do not apologize for wanting to do what was fair, but I have realized that I have to be in compliance. I've got to be strictly in compliance because all the good intentions in the world don't make up for not actually following the rules. And I've also learned two things that, I mean, shoot, you learn in kindergarten through this. And one is life isn't fair and 2 wrongs don't make a right. And if there's anything that I would add, I may make a number of mistakes. I have made a number of mistakes. I very seldom, if ever, make the same mistake twice. So there is a learning process I go through and have gone through. And unless there are any other questions, I appreciate the court. Rest.
Art?
Madam Chief Justice, members of the court. I am here and available for any questions. I would note that this was a case that Mr. Holmes sought reinstatement in this case. Reinstatement is set forth by our attorney discipline rules. It's in Supreme Court Rule 232. These rules and the procedure set forth in these rules were followed throughout this case. I would note that once Mr. Holmes submitted his petition for reinstatement and the disciplinary administrator's office was ordered by the court to conduct an investigation, one of the items we do is send out a questionnaire for the respondent to fill out. As part of the reinstatement process, this was filled out. In investigating Mr. Holmes and his ability to be ready to be reinstated and reinstated, there were those 3 docketed complaints that were mentioned. Those were fully investigated. The course of that process, as the court is aware, is that once a complaint is docketed, it is assigned to an investigator. It is investigated. The investigator submits a report. A disciplinary administrator reviews it, submits a report to the review committee, which is a 3-person panel that reviews all docketed complaints that come in through the disciplinary administrator's office. The review panel found with these 3 docketed complaints that probable cause did exist for violations of the rules of attorney discipline. And
Can I jump in and ask
Please
some
do.
questions about those 3? If those 3 informal admonitions were just magically out of this case, would the position of your office be different on reinstatement? And another way to say it is there anything else that's keeping reinstatement from occurring other than those 3 complaints?
I cannot speak specifically for the hearing panel that made the
That
recommendation.
was going to be my follow-up question. At first, I was going to ask about your office's position, and then I was going to ask you to sort of speculate about whether you thought the hearing panel found anything.
Sure, and Justice Stiegel, quite honestly, what we looked at and we considered were those reinstatement factors, those 9 reinstatement factors set forth in Rule 232. And it was the disciplinary administrator's office's position that these factors weren't met.
The reason,
Prior to the hearing, the parties were given the opportunity to submit exhibits, submit witness lists. Mr. Holmes submitted 4 exhibits. And then at the hearing, he only called himself. He was the only witness of which he presented. And in looking at the 9 factors, it would be my office's position he didn't meet those. Particularly, he was not conscious of the wrongful nature of his misconduct and the disrepute that the misconduct brought on the profession. His conduct since the court imposed the discipline, particularly concerning, was the finding and the acceptance that he practiced law.
okay, so let's talk about that a little bit,
Sure.
because that is what I want to talk about,
Sure.
is the finding and acceptance. Because as I read this, I'll just tell you, it's probably obvious from my questions. It strikes me that this case turns on those 3 informal admonitions. And I'll, again, sort of cutting to the chase, they strike me as incredibly thin as rule violations. But you educate me on that process. I mean, the complaint gets filed, so your office has to do what it's supposed to do, which you did, which is investigate and so on and so forth, and then present that to the respondent. And you know, how does this come about? The respondent just, it's easier not to fight this, so you sort of acquiesce so that you can get an informal admonition. Is that more or less a correct summary?
I cannot speak for why anybody would agree to an informal admonition versus asking that a disciplinary hearing be held, and that the office of the disciplinary administrator be held to their burden of proof that misconduct did occur and rules violations did occur. I can't speculate why Mr. Holmes agreed or did not to this finding and this resolution. The way it procedurally, the way it works is the review committee directs the disciplinary administrator's office of what actions it approves. And in these instances, it was authorizing an informal admonition or
Then the disciplinary
institute
office
informal
turns
charges.
around and uses that admission, which is it follows a good incentive. I mean, we want to incentivize settling these cases if possible. That's what an informal admonition really is. It's a agreed settlement essentially. And then that admission gets used pretty harshly, I would say, against the respondent to keep him out of being readmitted after he serves his 1-year suspension. I want to give you an opportunity to, I mean, I'm coloring the facts in a way that's not especially favorable to the disciplinary administrator's office. Is what's wrong with how I described that?
I think it's fair to say that attorneys are held to a higher standard of ethics and conduct than somebody who doesn't have a law license. While an attorney is suspended or disbarred, oftentimes, or on disability status, oftentimes docketed complaints or complaints are not necessarily dealt with or docketed because they are not practicing law. They're suspended, they're disbarred. In making the determination as to whether an individual has met the factors of reinstatement, I would submit that it's absolutely proper to look and see, are there unresolved complaints that weren't dealt with before the suspension occurred or that were submitted to the office of the disciplinary administrator after the suspension occurred that need to be addressed and need to be taken into account.
So the lesson here is that attorneys who face a reinstatement hearing are incentivized to fight every little complaint that comes in to the nth degree, because if they don't, it's going to be used against them when it comes to reinstatement.
I would note that if the disciplinary administrator's office docketed every little complaint that came into our office, we would be drowning in work. I would say approximately 1 in 10 complaints actually get docketed. And then there's several steps of review. Once the complaint is docketed, the attorney investigator, special investigator assigned makes a recommendation if a rules violation has occurred. That's then reviewed by a deputy disciplinary administrator or disciplinary administrator who then makes the recommendation to the review committee, who's made up of attorneys from the board of discipline. The attorneys that review all the complaints that are docketed and then submitted through these reports, it's the same 3 attorneys that review every single investigation that has come so as to have consistency and to avoid every little complaint being filed, but instead focus on the ones where there is evidence, at least to the level of probable cause.
But that leads to, I guess, really my last question. I know I've asked a lot of questions. I'm sorry for that. Substantively, what's your best argument that the facts, which I think are pretty undisputed, established an unauthorized practice of law?
I want to touch first on your comment that they're essentially undisputed, Justice Stiegel. I would note that the attorney discipline case law has long held that the Supreme Court gives the final hearing report the same level of deference as a special verdict by a jury or a district court finding. And if there is conflicting testimony or that sort of thing, that the Supreme Court recognizes that the panel, as the trier of fact, had the opportunity to observe the witness, evaluate credibility and demeanor. And as far as reweighing that, that's something that doesn't happen.
Yeah, I don't want to reweigh facts. My understanding is that there's really no dispute that the conversation at issue was between the respondent and the spouse of a former client. And the spouse said, hey, this person, I think, if I remember correctly, is getting out of jail soon. What can you do? And that the respondents said, I'm suspended. I can't do anything, but I can let you know when I get off suspension. And that's Would you agree that those are the facts?
I think essentially those are the facts.
So then
in this
my
case.
question is,
Sure.
I just want to hear your best argument as to why those facts constitute the unauthorized practice of law.
The respondent in this case made affirmations or statements to a potential client who was incarcerated. I'll be able to handle your case. I'll be able to handle I'm suspended right now. It should be done pretty quickly. I should be unsuspended. And I'm paraphrasing right now. But essentially he said, I should be unsuspended before your spouse gets out of jail.
Let me
and
ask a
you'll be able to
hypothetical.
handle
I
this."
know I said this is my last question. A student at KU Law School is a 3L. The student's grandmother says, "Oh, I'm so proud of you. Can you write my will?" And the student says, "Well, you know, I haven't taken the bar yet and I haven't been sworn in, but I expect that will happen this summer. And then I'd love to write your will, Grandma." Has that person practiced law without authorization?
That person puts the caveat before it in your hypothetical of, I can't do it, but I expect to pass the bar and then I will be able to do it.
And what's different about that from this situation?
Let me pull up the exact language that was used, Justice. I would point out in this instance, when once a reinstatement hearing request has been denied, there is a procedure where the respondent can file exceptions, much like anything. Those exceptions weren't filed, so the hearing report is admitted. And I would also note Rule 232 notes that a finding of notes that the court may request oral argument or written briefs on the matter. And in this instance, oral argument was recommended or requested. And coming into this, it was just being familiar with the record and being here and being available for questions such as yours.
And I appreciate that. I've given you a lot of questions.
Sure. And I would note that the hearing committee also spoke with Mr. Holmes about this, and you can see this on page 79 of the transcript of the reinstatement hearing that was held before the disciplinary administrator's office. Mr. Holmes noted in this hearing and in his words, his potential client was of the belief that Mr. Holmes was going to be able to represent him. And he notes, it reflected badly on me in the situation because I think he relied on me to be reinstated and he was hoping I would be. And he says that, any competent attorney couldn't have handled, but we deal in trust. And when you can't follow through with something that you promised, you lose trust. And that was wrong on my part. It was foolish on my part. And whether I intended it or not, it created a problem. And I think that goes to show, and perhaps I'm not standing here speculating as much, but Mr. Holmes is also of the shared belief that the statements he made, the affirmations or expectations he set forth with this potential client, this individual, was, I'm going to be able to represent you, and this person relied on him. And we have an attorney who's standing before the court asking to be reinstated today. And the reason he was initially suspended was because of saying things that were untrue. He made several false statements in the course of his disciplinary proceeding. And I would note in his final hearing report on the initial suspension that then the Supreme Court adopted in 307 CAN 871 in the matter of Holmes, paragraph 88 of that final hearing report notes, an attorney's word must be his bond. When an attorney cannot be trusted to be honest and complete in his recitation of facts, the attorney should no longer be entrusted with the practice of law.
I'm sorry, I didn't hear a promise, though.
Yeah,
I heard harm that may have resulted from reliance. Something somebody thought was going to happen, but I didn't promised he would represent him.
Let me, to that point, I want to clarify, having read the transcript, just to put this in context, tell me if I get something wrong here, that what happened was he represented this individual, and this individual went through all the preliminary stuff in Johnson County and Leavenworth County on criminal charges, but he was detained in Missouri for some criminal charges there. And so he's in jail. And the big mess up here, according to, Mr. Holmes, was that when he had no written agreement with this individual. And so the whole thing was when he was released from detention in Missouri, he still needed to be sentenced. And so the money he gave to Mr. Holmes, and please tell me if I'm wrong with the facts, the money he gave Mr. Holmes, he thought, hey, I paid for representation. In other words, a flat fee for both of these cases in Leavenworth and Johnson. And so I'm waiting for him to get unsuspended because I don't want to go pay a new lawyer. And so that's, but Mr. Holmes, not knowing that that's what he was thinking, because he later says, I never would have done a flat fee. So that's where the complaint came out of, when it comes out that no, even if I did get unsuspended or released from suspension, I'd charge you anyway. That was the impetus for the complaint in this case. Is that correct? Because this is the client that, it wasn't necessary, it was to extent reliance, but that's the way that I understood it. And so even Mr. Holmes, who really fell on the sword here during this testimony and said, that was my bad. I didn't have a written agreement with this guy. And so he took a CLE class. It was ethics. And, and he testifies and says, I learned right then and there, this is while he's suspended. I learned right then and there, I got to have a written agreement with my client, because I didn't have a written fee agreement with my client. So contextualizing all this, that's what happened. Is that correct or not?
Yes.
Okay.
That is correct, in that he continued to client through the spouse while he was suspended, which is something that you specifically out of law license is clients about the status of cases and he's communicating with his client through the spouse as far as hopes and desires and things that he hopes to do, and expectations that I should be able to handle this. I should be unsuspended pretty quickly in this case. And then that in fact did not happen.
But what happened, I don't know from reading this, but at some point what happens is, and I probably do have the complaint. I don't know whether I have a complaint or not. Probably in the record, I do have the complaint, but the complaint is more about the flat fee thing, right? Than about, wasn't that the complaint, but then it was, investigated as unauthorized practice of law. Cause I think when it came out that I'm not going to do this for free, then it's like, so he, I'm going to get unsuspended. I'm going to get unsuspended. So it wasn't like, oh, I might not get unsuspended. It's like, oh, you think that I'm going to be doing this for free? No. right? Or not?
But again, it's the articulation of, we're discussing what I'm going to do as your attorney and how I'm going to handle this. And we're going to talk about the fee agreement and what's going on. And all that discussion is ultimately what results in that unauthorized practice of law. And, you know, in this case, we're looking at, yes, 1.2 scope of representation, and, you know, 1.4 communication was adequate communication. And because there weren't these two other things, it also results in that unauthorized practice of law finding, is I think how we would get there. I would just ask members of the court that this is a case where once the final hearing panel submitted their recommendation and finding that Mr. Holmes did not meet his burden in proving the 9 factors set forth for reinstatement in this case. And in looking at that final hearing report, it wasn't just, the panel didn't just look at, oh, you had IAs, so you accepted IAs, so we're not going to reinstate you. You know, they looked and they found that Mr. Holmes did not establish that he was his consciousness of the wrongful nature of his misconduct and the disrepute brought to the profession. He did not meet that. That the serious of the serious does not preclude reinstatement. That his conduct since the court imposed the discipline did not meet that. His compliance with Supreme Court orders, he did not meet his burden in proving that factor, that he did not engage in the unauthorized practice of law, that he did not meet that factor. The panel looked at the totality of everything. Mr. Holmes was afforded due process. He was given the ability to present argument, to present exhibits, to present letters of support. He was given ample opportunity and time to get to the place where he could prove these factors. And when he came to the reinstatement hearing and called himself as his only witness, submitted 4 exhibits, and his lengthy testimony under oath to the hearing panel, both where he was given the ability to and the opportunity to present everything that he wanted to present testimonially and evidence-wise. He was subject to cross-examination by the Office of the Disciplinary Administrator. And then if you look at the transcripts, or you look at the transcript of the reinstatement hearing, the 3-member panel of the reinstatement hearing also engaged in some extensive back and forth and questioning of Mr. Holmes under oath. This was a time where they had opportunity to evaluate and make that determination if he met his burden of proof. They found he didn't and issued the final hearing report. And not only did they find that he didn't, Mr. Holmes had the ability to take exception to this, to say, I should be reinstated. I object. I don't agree with this finding of fact. I don't agree with this conclusion of law. He was given 21 days after the final hearing report was issued to file these exceptions. He did not file exceptions. And as such, he essentially has agreed to the findings, and not essentially, he has agreed to the findings of fact and conclusions of law. So we're here today where all the parties involved the disciplinary administrator's office, the hearing panel, and the petitioner agree with all the findings of fact and conclusions of law.
Which rule is it that says if you don't file exceptions to a reinstatement panel hearing report? Can you cite can you tell me which rule that is so I can look at it?
So Rule 232 is your reinstatement following suspension or disbarment. And looking at Rule 232 under subsection G4, if reinstatement is not recommended, the petitioner may file with the Supreme Court an exception to a finding of fact or a conclusion of law no longer than 21 days after service of a copy of the reinstatement final hearing report. And in this instance, the disciplinary administrator's office waited that 21 days to give Mr. Holmes that ability to, file exceptions, and this did not happen. And it was once that was done that it was submitted.
And do you know, and this I'm asking because I don't know the answer to this question.
Sure.
Does that mirror identically the rule that talks about filing exceptions to a hearing panel report on a disciplinary complaint? In other words, the part about if you don't file, they're deemed accepted. Is that different or the same?
Well, I want to clarify in Rule 232, there's nothing in that rule that specifically says if you do not file, they are deemed accepted.
But there is that provision in the I'll call it the regular exceptions to a hearing panel report. It expressly says that in that rule, if I remember correctly. Do you? And I'm going to be embarrassed if I'm wrong on
Sure.
that because I should know the rules.
I certainly don't. For memory, Justice.
Well, it would be perfectly
but I
fine to
can-
question it.
I have it here. It's in subsection G. That rule, it says the disciplinary administrator and the respondent may contest the recommendation. I'm sorry, I had it here and I just lost it. The respondent. If the respondent fails to timely file an exception, the findings of fact and conclusions of law in the final hearing report.
And that's in the final hearing report rule, correct?
Thank you, Chief, for actually looking at the rule. Does that make any difference? That distinction between these two rules? Difference?
I don't think it does because the rule that we are talking about here that Chief Justice Lukert quoted from is Rule 226. And that rule is I apologize. 228G is the procedure before the Supreme Court. And what that rule talks about and what I'm looking for in this, because initially what I was thinking, when you look at Rule 226, which is the final hearing report rule, that rule initially talks about following a hearing on a formal complaint. And because a reinstatement petition is just a little bit different animal than a formal hearing complaint, I wanted to go and look at 228 and see if that references a formal complaint versus just a matter or action in the final hearing report. And I think that because it's distinguishable, from that, and it just refers to the final hearing report and submitting the exceptions, I I don't necessarily think that that makes a difference in determining whether the findings of fact and conclusions of law are all deemed admitted or not if exceptions aren't filed. I think that it would be meet and right and appropriate to refer back to that Rule 228 to determine that. And if there are no other questions, thank you very much. I appreciate it.
Reserve 5 minutes.
Madam Chief Justice, may it please the court. I would only like to touch on a couple of things that were brought out by the disciplinary administrator's office this morning. One is an assertion that somehow I have failed to accept seriousness of the underlying offense, or that I failed to appreciate that. There was a statement provided in my testimony by the disciplinary counsel herself that I believe belies that. That is, and I had made it in a number of occasions of what this has done to my clients, that I had lost trust. I had also lost trust with the profession. I had made it clear that I believed that the underlying act for which I received the suspension was based upon a good intention, in that I saw a horrible injustice being perpetrated. And I acted right after I found out that I had an administrative suspension. That was the mistake, and I recognize that. But I believe that it is incorrect to conflate that sense of wanting to bring about a just result with a failure to appreciate the wrongfulness of the conduct. Do both. Say, well, I had a good intention. Boy, was I wrong. And I made that, I believe, clear in the panel. Secondly, and I don't mean to disparage counsel in this matter, but there's a lot she got wrong. During the course of the hearing, statements were made about things that I had allegedly done I didn't even recognize. There were statements made about where I had practiced, what state, that was wrong. I believe that there have been misrepresentations made about me and my character throughout this proceeding that unfortunately, I believe reflected on the panel. I also believe that with respect to whether or not the findings of fact are absolutely binding is distinguishable from Rule 228 in the sense that we're dealing in the first place in this situation with a hearing panel, and it's my understanding that this body is the final arbiter, not the hearing panel. That you are free to look at the evidence that was provided, not to counteract, or not to ignore that evidence, not to reject it, but to certainly countenance in the context in which it was provided, which may not always agree with what the hearing panel says. And I think for that reason, that's very different from Rule 228, which makes it explicitly clear than the context of a hearing before the Supreme Court. Any exceptions that are not made to the Supreme Court are deemed admitted.
Mr. Holmes, to that end, and I don't know if you're done, whether you just had to.
No, go ahead.
Okay. Of what was presented in the transcript. I'm kind of late in the transcript, page 97. One of the hearing panel members said, when this hearing started with your original testimony, you said something about how you didn't particularly trust lawyers. And you said yes. And it says, do you have a network of colleagues in the legal profession? And you immediately say, no, I wish I did, but I've had so many bad experiences with attorneys that it's difficult for me to trust other attorneys. And then you basically go on to reiterate that you just don't, let me tell you, I wish I had an attorney that I could rely on oh, who do you call when you need help? What's your support system? And you did mention one person, but you can't find him because he's retired. And, but is that still the case now? And
Do I have a distrust for attorneys?
distrust, and do you have a colleague that you could find support in?
I
Because if you
believe
do,
I could find a colleague. And I believe that I had mentioned in the context or in the course of the preceding incidents that have taken
right,
place,
I read that.
that, I mean, I got burned right from the start. My very first boss went to prison. And I've seen situations with attorneys who, in my mind, have done the most reprehensible thing. And yet were patted on the head for being really clever. And yet what they amounted to be doing is essentially what I believe is legal arson.
I guess my question
I think I
is-
carry a little bit of PTSD because of
Right.
that.
But my question more is, I think it's great about the CLEs, but some of the things, decision-making, or even while you're suspended, the incidents that happened while you were suspended, I mean, can you practice law in a vacuum without any legal colleagues?
Not very well.
And I know
There's what you can do in
yeah.
vacuum.
There were you didn't submit, you talked about the fact that you had trouble finding any lawyers at all to write a letter of recommendation for your reinstatement.
I contacted close to a dozen. All right, let me rephrase it. I endeavored to contact close to a dozen. I was able to contact a few. And I was either told in so many words, I like you, I wish you the best of luck, but I really don't want to get involved. Or just no call back, or I absolutely could not get a hold of them. Can I find somebody? Probably. Do I have a close-knit group of attorneys that I associate with on a regular basis? Not really. Do I have a good, solid base of support? Absolutely.
I read that too.
Absolutely. My family, my coworkers, as a solo practitioner, which is what I was for most of my practice, you don't always get to be a team player. And that's something that I have rectified in my current position. I work with a number of individuals doing what amount essentially the same thing. We all kind of have our different specialties. But I have to work with these people, and I've learned to work very well. I can work in a team setting, and I enjoy that. I have been burned by attorneys. I've been burned by judges. I learned a long time ago that for every Antonin Scalia out there, there's a Roland Freisler in the wings. And so it's, and no disrespect to this body, but it happens. And it's something that fits with you.
Very much.
But yeah, I think I could find something.
Thank you.
Thank you.
Thank you to both counsel. We'll take this under advisement.